But can you tell me a little bit, because this is a little bit different in Pennsylvania. You talked about a divorce master. What is a divorce master?
So as I understand it, Pennsylvania has a tiered system. So the judge, who by the way, the judge, obviously, as we know, is appointed by the bar associations, which which is comprised of the lawyers.
As one person says, a judge is an attorney wearing a black robe.
And actually, in Pennsylvania, I believe that it's you only need to make application, and in 30 days or something, you can be a judge without any background whatsoever. So,
right.
But at any rate, this this judge appoints the divorce master. The divorce master is just a lawyer who then has the hearing. In fact, what's interesting is that we went before the divorce master, we had the hearing. The divorce master actually told me that this is above his pay grade. He said that, this is all on the recorded record of the testimony of the court. It's above his pay grade to make these decisions. He actually said that I have some very good arguments as to why this is unconstitutional. And he went on and said that he actually said he's not smart enough to make these decisions. That was his exact words, and that he said it would be an extremely interesting and complex issue for a judge to hear. And that we would get before
if the judge acted like a judge.
And that we would get before a judge for the judge to hear these arguments. At the time, it was in a couple. He said in a couple months was when the hearing would be. So we had a hearing then for the exceptions to the master's report, because the master then files a report to the judge. We had that hearing, and at that hearing, the judge told me, well, the master made a recommendation, so I'm only here to hear exceptions on that, and I'm not here to do anything in a judicial capacity.
The judge told you that?
Yeah.
On record?
Yes. So
a judge not acting in a judicial capacity, what is this nonsense?
So she said that, she's not here, she's going to hear in a judicial capacity, according to her, she'll hear the arguments of exceptions to the master's report.
Right.
But really,
so
I haven't had an opportunity to go before a judge, and as I understand, I'm entitled to a hearing before a judge, not just simply a hearing before another lawyer who is appointed as a divorce master.
So basically what I'm hearing you say is that the divorce master is actually making the decision that the judge is enforcing, not acting judicially, enforcing. Again, it is a big problem here with the judges not acting in a judicial capacity, which therefore means that judge can be sued.
Because simply making ministerial decisions, administrative actions.
Right. So why not, instead of a judge, just have a bookkeeper down there? Why do we even have to have judges for divorce if these are the shenanigans that are being done? Because the judge will never say, I'm denying the divorce based on the evidence. Number one, because there is no evidence that's needed. Number two, you can lie about evidence because this is, family court, and perjury is completely acceptable. It's absolutely ridiculous. It's a foregone conclusion. And due process says that you have a right to be not just heard, but meaningfully heard. And that you should, and in the 14th Amendment, it mentions both due process and equal protection under the law, but what it's actually taking place is that the decision is being rendered favorably on behalf of the plaintiff without any examination of anything.
The 3301D statute in Pennsylvania just simply says that the plaintiff must say under oath that the marriage is irretrievably broken. And meet a predetermined requirement of living separately and apart now for 1 year. In our case, the law actually changed, and we fell right before the law changed, so we were 2 years of separation. But as long as she's met that requirement of a time frame living separately and apart, and says under oath that the marriage is irretrievably broken, then the judge 100% of the time will rule in favor of the plaintiff.
So and I'm actually from Pennsylvania, so I know a little bit about this stuff, but I remember growing up, we used to have this thing, like if you cross your fingers behind your back, you could swear, but I've got my fingers crossed, so it doesn't apply to me. And that's really what's happening here before these judges. I swear, Judge, that our marriage is irretrievably broken or whatever, and there is no fault. But by the way, I want to take him for everything that he has, because somehow with this no fault, I also get to take everything at the same time.
Well, you can, she can take access away from our children. She
Right.
can, if she wants to, she could file then for judgments monetarily against me, things like that. What's interesting is that the courts actually in the statute in the Title 23, Section 3102, they actually say that it's the policy of the Commonwealth that says the family is the basic unit in society, and the protection and preservation of the family is of paramount public concern. Therefore, it's the policy of the Commonwealth to encourage and effect reconciliation, especially where children are involved, and to give primary consideration to the welfare of the family. Now,
It says that
it says it
specifically.
specifically
You're
in
reading
the
that.
statute,
I'm watching
right from the statute.
Yeah.
That's right in the statute. Now, when I brought this to the attention of the judge actually told me that that is, in fact, it's in black and white, that's the statute. She said, however, that it's her job to move these things through the courts quickly, because could I imagine if these things were tied up in the courts, just bouncing around in the courts? So therefore, their interpretation of that, the best thing for the family to encourage and preserve the family is to move these families through the courts. In fact, as I walked out of the courtroom, the judge actually, her statement to me was exactly this. She said, "You're just one more family and one more custody case." That's what she said to me. So I turned around to her and I said, and that's exactly the reason why I'm doing what I'm doing, why I'm here.
Good.
So,
We're with you 100%. There was a judge last year during the primaries. There were some judges. I don't know if you saw any of these videos that I did with her, but there was one lady judge. She was running for judge, and she said, "We're not destroying the family. We're reorganizing the family." And I said, "You mean like in a bankruptcy?"
Well, I think you're making a lot of assumptions about certain specific incidents.
Okay,
What I
so
would
tell me
say-
what my assumptions are.
Okay, your assumption is that divorce tears apart a family.
Well, it does.
Well, I disagree. I think that divorce done well is a reorganization of a family.
So you're talking
never
like bankruptcy, like in the company that's filing for.
What we aim to do is just restructure a family that is not going to be together as a unit like they were.
Because one person says, "I don't want
One person said,
it."
"I don't want it."
And actually the thing was with this judge, she told me, and this is all on video, I have daddy issues, because growing up, she went through this. I have daddy issues. So here's a judge with daddy issues, has been through a reorganized family, as she would call it. And if two people want to do this, and I said, I'm talking about unilateral divorce, one person.
The issue that we're talking about is the no-fault divorce, in which one person is filing for the divorce and the spouse says, "I don't agree that this marriage is irreconcilable." Now you're saying like both parents are at fault here, but it's one person who's actually destroying a family, and you're saying that you're okay with that.
Well, I am, because as a scholar and as an attorney, although I am a Christian and I strongly believe in God, I don't think that every family sees their marriage as a covenant with God, a promise to God. Furthermore, maybe they do, but circumstances are different at this time. So I want people to have an opportunity to get divorced however they want to.
However one person wants to, not however they want to.
Two people get married by mutual agreement. You propose to your wife accepted, that there's two people there. But when you have one person that can break the marriage is no longer a legally protected entity. And that's what we're fighting in Texas right now, is this idea of unilateral divorce. And that's also what you're fighting here in Pennsylvania.
In Texas, we have no-fault divorce, which I'm going to call unilateral divorce, because in the majority of instances where one person is filing for no-fault divorce, there's no reason whatsoever. It does not have to be a mutual thing. It's forced divorce. And you have, the statistic that I've read most frequently is 75% of the cases, the respondent does not want the divorce, be it a woman or a man. And in even higher amounts of cases than that, the children don't want the divorce. They want their parents to work things out to stay together. But you're a defender of no-fault divorce. Tell me why.
Well, first of all, no child wants a divorce. But children don't make grown-up decisions.
Well, grown-ups are using grown-up arguments that affect the children. But anyway, go ahead.
Well, I would agree with you. Every family court case affects children, and if the parents can't reach an agreement that's in their best interest, then they have to look to us judges to make those decisions for them.
So you're saying you're okay with forced divorce? Now you mentioned, and I'm going to ask you honest questions. I'm not. I hope you're not offended.
I'm not. I've represented that client.
Okay. So you mentioned
we call it a divorce readiness scale. One spouse is at 10, and the other one's at 1. So how do we handle the one client and move them toward, because this is not going to get different.
Well, how do we protect the due process protections of the respondent in a situation where something is being forced upon him? Because part of due process, divorce is a lawsuit, as you know. Somebody's suing another person, and in an instance like that, you either need to have something that you can bar the lawsuit, or you have to have the opportunity to present evidence to say, I'm innocent. In no-fault divorce, you get neither one of those things. So on its face, it is unconstitutional. It violates due process protections for the respondent who does not want the divorce.
Well, I disagree with you. I think the respondent has been sued, right, wrong, or indifferent. The case is going to go on because the petitioner had the right to file the suit. And so the respondent has every right to hire their own counsel, to do their due diligence in discovery, obtain their own expert witnesses, just because they didn't want the lawsuit.
It doesn't matter though, because even if they go through all of that stuff, you're going to grant the divorce.
Have to.